So, welcome to this IC Medico Legal Update, current scenario for ophthalmologists. So, presentation. Viral Shah. Viral Shah. Intro. Good morning, everyone. Good morning, Deshpande sir, Dr. Prasann. So, we are here with our Medico Legal Update IC, current scenario for ophthalmologist. I am Dr. Viral Shah from AIOS Hospital, Nagpur. So, as we all know, these are very turbulent times for ophthalmic practice. Eye care centers being told left and right to pay compensation to patients for their vision loss, and such headlines you will see daily in your newspapers or social media posts. So we designed this medical legal update with myself, Dr. Viral Shah, as chief instructor, our mentor, Dr. Anand Deshpande sir from Aurangabad, Chhatrapati Sambhajinagar, Professor Dr. Rajesh Joshi from Nagpur, Dr. Hari Krishnan, Major Dr. Hari Krishnan from Hyderabad, and Dr. Prasanna V. Ramesh from Trichy. So, unfortunately, Dr. Hari Krishnan cannot join us because of some family emergency. He has to leave for Kerala. So, for this IC, I will be speaking on the new Bharatiya Nyaya Sahita, important highlights for ophthalmologists. Dr. Marathe was supposed to speak for CPA 2019. Dr. Deshpande sir will speak about dealing with legal notices, be practical and prepared. Dr. Rajesh Joshi will speak about medical records, most important evidence in court of law. Dr. Prasanna V. Ramesh, he will speak on medical legal aspects of teleophthalmology. And professional indemnity insurance was supposed to be covered by Dr. Hari Krishnan. So, without wasting much time, I will start with my first presentation. Next presentation. Regarding Dr. Viral Shah, BNS. वहीं पे. Next presentation. Ready. So, thank you at the outset to APO, AIOS, Scientific Committee of AIOS for giving us this opportunity to conduct this IC. Bharatiya Nyaya Sahita 2023 is now in force. So what are the important highlights for ophthalmologists I will be covering? Myself is Dr. Viral Shah from Neaksha Hospital, Nagpur. So such advertisements by IMA was there on 22nd of December 23 in all leading newspapers, in which the ads extended its gratitude to Prime Minister and the Union Home Minister for exempting medical professionals from the criminal prosecution for causing death due to rash and negligent act. But in reality, the new provision has not granted any immunity to the doctors from criminal liability. Rather, they have become more serious and dangerous for the doctors, and I don't understand what was the hurry by the IMA leaders to give such an ad without reading the actual document. Section 106 of the BNS, their provisions are applicable to medical practitioners who possesses any medical qualification recognized under NMC Act 2019 and whose name has been registered in the National Medical Register or State Medical Register under the Act. This means these provisions are applicable to all the MBBS doctors. Section 1061 of BNS, it deals with causing death by negligence. In the old Act, the Indian Penal Code corresponding was 304A IPC. So what has changed in 1061 BNS as compared to 304A of IPC? So there is got two parts or two limbs. The first limb deals with any person excluding the MBBS doctor. That means Ayurvedic practitioner, Unani, homeopathy, whatever, or some quacks. So if they cause any death to any person by doing rash or negligent act, not amounting to culpable homicide, then the said AIOS doctor shall be punished with imprisonment of either 5 years and shall also be liable to fine. So here they have replaced or imprisonment or fine with imprisonment and fine. Thus, as per this new act, both jail sentences and fines are mandatory for AIOS doctors also. The second limb of this section deals specifically with MBBS registered practitioners. If MBBS registered medical practitioner while performing medical procedure causes death of any person, then imprisonment of 2 years and fine. So for MBBS doctor registered for 2 years and fine, and for other practitioners except MBBS it will be 5 years and fine. So even MBBS doctors are covered, and this now mandates jail sentence as well as fine both. Previously judge had the power to give some fine and let the prison sentence be suspended, but now as per the wording we don't know whether they have the powers right now. So first this judgment is yet to come. Whenever the first judgment comes under this section, we will know how the judiciary interprets it. Thus, the new act is more dangerous to the doctors, and specifically it is more dangerous to the AIOS doctors. If the doctor is convicted by the court under section 1061 of it, then a jail is mandatory. Punishment for doctors for not treating the patient. FIR to be filed against doctors under section 200 of Bharatiya Nyaya Samhita. So there were such posts on the WhatsApp and various social media where the caption had created fear amongst doctor. This was nothing but mindless sensationalism by media, where it was said now treating a patient, if we don't treat a patient, concerned doctor will be punished with 1 year jail or fine. Same provisions were there in the previous IPC under section 166B of the IPC, and there is no major change between 200 BNS and 166 of IPC. Specifically, the cases of acid attack victims, victims of rape, including gang rape, and child victims of sexual assault and penetrative sexual assault. These cases have to be treated by any practitioner, including ophthalmologist, if they come to your OPD. You may not have much resources to treat them, but just give them some first aid and refer them to the nearest government hospital or tertiary care hospital, and you have to inform the police that such and such a case had reported to your hospital, and please take note. So these two steps if you do, you don't come under section 200 of BNS. Thus the caption was highly misleading, and it was wrong and had no legal validity. So just follow these two steps. Document the patient had come to your OPD and you have given some primary treatment, and keep proof of police information and receipt from the police department acknowledgement. When can the FIR be filed against a doctor under section 1061 of BNS for causing death of the patient? And also, is it false to file a false FIR against doctor? FIRs are filed against doctor under section 1061 of BNS, but here we must understand whether that FIR will be tenable, thus filing false charges of offence by police constitute an offence, and what are the views of SC about it. In spite of Supreme Court's many observations, FIRs are routinely filed by police without application of mind, and trials are framed by the courts under section 1061 of BNS, even when there is no evidence to point out the existence of intention or knowledge required. Therefore, doctor has to approach multiple courts to quash the FIR or charge sheet. Various landmark judgments are there regarding this, and appropriate section has to be applied. Section 240 of BNS, filing a wrong or misleading or prejudicial FIR against a doctor shall be punished with imprisonment up to 2 years. So expectation from the police official not to file FIR against doctors under section 106 if prima facie there is no evidence and it fulfills the major ingredients of the said section. So what has now become the rule for filing FIR under BNS? So as proposed by Bharatiya Nyaya Sanhita 2023, some key aspects are FIR is now mandatory. You have to file an FIR. It can be filed digitally. There is a timeline, specific timeline given for investigation, and there are stringent punishments for perjury and false FIRs. This proposed changes reflect a move towards modernizing India's criminal justice system by increasing transparency, reducing delays, and leveraging technology for more efficient processes. Key provisions related to medical practitioners. The punishment for causing death by rash or negligent has been increased to 5 years for non-registered medical practitioners and 2 years for registered medical practitioners. However, for medical practitioners, grievous hurt, the definition and duration of grievous hurt has been modified. Previously it was 3 weeks, now it has become 2 weeks, 15 days because of advancement in medical treatments. Now they are the opinion that patient can get treated faster with latest armatory available with the doctor. Legal safeguards has been given to doctors. Medical practitioners are generally protected from frivolous claims, though the need for expert medical opinion to establish negligence. The BNS does not specifically alter the requirement for expert testimony, but continues to rely on established legal and medical standards for determining the malpractice. Expert opinion is crucial and a must wherever a medical negligence case is filed. Courts often rely on testimonies from medical professionals to understand the standard of care and whether it was breached. Judicial consideration, courts consider the complexity and the risk inherent in the medical procedures, the practitioner's intent, and adherence to established medical protocols. So, various scenarios where the FIRs can be filed under doctors for medical negligence, death or harm. It is similar to one IPC 304A. Fraud or cheating, medical bills, false certificates under IPC 420. Sexual harassment or assault by doctor, illegal medical practices and unlicensed procedures, forgery and falsification of medical records, organ transplantation and drug violations, endangering human life or personal safety, drug violations, and criminal breach of trust, misuse of patient's fund. So this is all about the new Bharatiya Nyaya Sanhita which has come and how it is going to impact us in the future. And as time passes, we will know as more and more cases are filed and it becomes in the public domain, we will know more how this BNS is taking shape. Thank you. Thank you, sir. So next I would call Dr. Dr. Prasanna Venkatesh for medico-legal aspects of teleophthalmology. He is a Joint Secretary of Young Ophthalmology Society of India and is currently practicing Trichy.
Thank you, sir, for this wonderful opportunity to not only speak, but I also learned a lot from seniors on the dais, and it's a great opportunity for a neophyte like me to interact and learn. So my talk for the next 10 minutes is going to be medico-legal aspects. Can I have a pointer? Pointer. Of teleophthalmology and AI. So we are talking about teleophthalmology today because COVID actually accelerated teleophthalmology to an extent, because we started practicing teleophthalmology, or the era of COVID actually accelerated this whole process. And teleophthalmology enables remote diagnosis, monitoring, and management of eye diseases, which we all know. And this is used for community screening, even like health fairs, places of worship, etc. And diagnosis of diseases like diabetic retinopathy, glaucoma, and it really helps you to get the chunk lesser. You are able to go, or rather the patients are able to meet you from a virtual place. So that is the beauty of teleophthalmology. And who can practice? Any registered medical practitioner who is registered with either the Indian Medical Registry or the State Medical Registry can practice. As of right now, there are no particular qualifications are needed, but in order to allow an RMP to practice telemedicine, the government intends to launch an online course that must be completed. And this is the one that you can see, at least for the viewers on YouTube. So this is one that is very important because that has to be completed, and the governments are trying to regulate the process of who can practice telemedicine. And the online program will be developed and made available by the Board of Governors in supervision of Medical Council of India. And all registered medical practitioners who intend to do it should complete this mandatory online course within 3 years of its notification. So the regulations are happening, and in the interim period, the principles mentioned in these guidelines should be followed. So thereafter, undergoing and qualifying such a course as prescribed will be very essential to the practice of telemedicine, and these are all regulatory efforts to channelize the proper channel. Consent is one thing that is assumed when the patient starts teleconsultation. There are two things. One is an explicit consent approved before the RMP begins, which can be either due to a text, email, phone, or a video, any of these four. So what is an explicit consent and what is an implicit consent? If the patient is the one who is initiating, then it is considered as implied, and you can just tick a point there. An explicit consent required when the healthcare worker or the caregiver, he initiates the consultation. So that's the catch here. So basically, if we are initiating, the healthcare worker is initiating, then it has to be very documented very clearly. So the email, text, audio, video, messages from the patient is actually a consent. You can tick it. Verbal confirmation also is preferably over a video. And RMP must record the consent. That's more important. Whatever the documentation, it has to be recorded. Ethics and confidentiality. The registered medical practitioner must uphold the IMC Act ethics, ensuring patient privacy and confidentiality, because caution is required when the technology is especially used, because we don't want any breaches. So the blockchain technology, big data, those are some of the terminologies that you can actually associate with these kind of things, and making sure the 6 rounds here, the rules, values, moral principles, ethics, rules of conduct and research are kept in mind. E-prescription essentials, after gathering enough data for diagnosis, only should be the prescription given. Prescribing without a diagnosis is considered a malpractice. It has to be kept in mind. Medicine prescription in telemedicine are regulated by the central government, and this is a very important list, my dear friends. List O, List A, List B, and prohibited list. So the telemedicine specialist should know what are the lists that actually falls under which category. Like a paracetamol is a common one that you can give. List A, local ophthalmic drops and following up for chronic medications. List B allows add-on medications for existing conditions, whereas there is this prohibited list of narcotics, psychotropic substances, and morphine and cocaine. The cost structure may change, or rather the RMP may charge an appropriate fee, and an RMP should also give a receipt or an invoice. That is also something which is very important. Need for standardized telemedicine laws is the need of the hour. That is when WHO recommended on digital interventions, where it recommended put telemedicine systems in place to ensure data privacy, ownership, access, integrity, and protection of the patient's information, because ensure that these system meets the national legal standards. Because the major concern here is the patient confidentiality and the data integrity, especially if unauthorized interaction. If you don't have a good firewall, then that is a cause of concern if the patient's data is going to be leaked. That is why WHO serves both as a development incentive and a limiting factor, allowing individual states discretion in implementation. The tele-ophthalmology governance in India is the Department of Information Technology and the Ministry of Health and Family Welfare, which oversees it. National Telemedicine Portal has been established by the Ministry of Health and Family Welfare, Government of India's Telemedicine Division, and the legal ramifications of telemedicine include necessity to follow the telemedicine practice guidelines, which specify patient record keeping, data confidentiality, and the obligations of the healthcare professionals. Furthermore, it is critical to comprehend and abide by any data protection legislation, such as Personal Data Protection Bill, which has to be kept in mind while working with the patient. Healthcare professionals involved in telemedicine must be updated about any modification or changes in rules, as the legal landscape keeps evolving constantly, and this is one where the IMA seeks clear-cut guidelines on telemedicine from the Medical Council of India, and this change of information or the need to know more, because the evolution is keeping on happening. For clear-cut guidelines, the negotiations is going on where we are just evolving every day. The telemedicine practice guidelines in response to the national crisis that happened in COVID, you can see in 2020, the Ministry of Health and Family Welfare released the telemedicine guidelines on March 25, 2020, and it paved the role for a game changer in telemedicine. And this was the document that you can see on 25th March 2020. Because of COVID, the telemedicine governance in India, the constituted were developed in collaboration with NITI Aayog, which is a premier policy think tank of the Government of India, and they aim to offer framework to help RMPs who are interested or engaged in telemedicine. The role of the IT Act 2000 is something we need to know, which regulates electronic communication, covers telemedicine related legal aspects, ensures cyber security, because as you can see again, the 5 arms here: legal, electronic, promotion, and the regulation and the privacy laws. These are the main arms, because sensitive personal data or information, SPDI, is what we are worried about, which is considered sensitive under the IT Act, and that is where the National Digital Health Mission guidelines to protect the standards of it comes into play. Patient can create their health ID, patient can control, access their health data, and it is only having an authorized entitle and shared only with authorization. AI is something which is entering ophthalmology, being an imaging field, and it is helping in detect conditions like diabetic retinopathy, glaucoma, and whatnot. So in the era of AI, imaging assisting is being done, and it reduces the workload. And these are some of the AI modules that I'm also personally working on, where you develop an AI from a baby to an adult called human in the loop learning. And what I have realized is there are potential issues like algorithm bias, data privacy, accountability in misdiagnosis should be kept in mind, because in the court of law, you cannot blame the AI. It's the doctor who puts his hand up and his signature will be taken in the court of law. So AI enhances the diagnosis, but there is a barrier. Patient follow-up remains a challenge. Regulatory restrictions and insurance reimbursement issue limits adaptation. Cost and implementation difficulties is one that we need to keep in mind. And the potential risks, again, as I told you, bias, misdiagnosis, and misinterpretation are one. But these are some of the global efforts that are taken, like Kid Drop, Veteran Administration in US, COVID-19 accelerated telemedicine, and there are many cybersecurity and data protection like the CDPR, HIPAA. I'm not going into the detail of it, but which we should very well know. And AI is there to stay, because ophthalmology is moving towards this, but patients often distrust AI driven diagnosis. That is one thing we need to keep in mind. The patient distrust it, and AI should not augment, or it should only augment, it should not replace when you are trying to use AI for it. And it's not going to be doctors versus AI, it's always a doctor who will be blamed, and it has to be kept in mind in the ethical considerations and whatnot. So FDA has a role, IMDRF and SAMD has a role, and these are some of the documentation, and it also has its own arms, and I'm not going into the detail of it for want of time. And there is a Drug and Cosmetic Act of 1940. So these are some of the references I wanted to give: medical devices rules, regulatory framework in other countries, like even the Patent Act and the intellectual property. I'll just take 30 more seconds, sir. Yeah. Many countries struggle to keep pace with AI. That is where the other rules in other countries have come into place. And this is my last slide, my dear friends. To summarize this whole topic of tele-ophthalmology, which has some amount of AI also coming into it, with the companies or even the doctors pushing for it, where AI in healthcare, including tele-ophthalmology, offers significant advancements but must be ethically and legally regulated. We are at the crossroads of it. Point 2, it has immense potential but must be ethically regulated, and the trust is critical, because patients don't trust AI. That is to be kept in mind, particularly in telemedicine when AI supports remote diagnosis. Clinicians should be staying informed and involved, especially very more vigilant when AI adaptive tools are used, and patients' trust and safety, be it their records or be it misdiagnosis, remains the highest priority. These are my references. Thank you once again for the opportunity, sir, and the whole team. Thank you.
Dr. Prasanna, that was a wonderful lecture on AI, teleophthalmology. No, I just want to ask you one question, which is not really related to your
Yes, sir.
topic, but AI is being used extensively for
Yes, sir.
creating a research,
Yes, sir.
and I come across many such articles nowadays that language is entirely different,
Yes, sir.
and there is no correlation between the first paragraph and the second paragraph. Now, unless and until you read it thoroughly, you will not get an idea about it. Do we have some softwares which can detect such type of write-up, particularly in research?
Sir, we do try to check it with plagiarism softwares, but unfortunately, those softwares are well made, like a DeepSeek or a ChatGPT. They are well made in such a way that we are not able to fully detect it. But as you rightly told, sir, I always strongly believe, though I am doing extensive work in I do a lot of human in the loop learning. When you read a paper and you feel that it's too good to be true, and the language that comes with it, even if you see currently, sir, even in WhatsApp messages, or when you form a particular, we know the messages that this was not composed by that person. They just used a deep seek or something like that. So human intelligence is way, way beyond, sir. I always feel human intelligence is very capable, and I think you or the other seniors being in very pivotal roles. When you see a paper, its human intelligence will easily pick up that it's actually not written by a human, whereas it's written by a artificial
Yeah.
intelligence tool. And it's very unfortunate, sir, because if somebody is publishing with the help of AI, I just feel bad for them, because it's their loss actually. They need to evolve and they need to do the work. So that will be easily seen. As of now, the softwares are not very much there for it, because these softwares are very advanced, sir. The one that's coming, the DeepSeek or ChatGPT or even Grammarly for that matter. So as of now, I have not used any softwares where you can actually identify the plagiarism. But when I see a write-up, I'll be able to make a note that yes, this is not written by human. That is something we get to know by experience, sir. Yeah.
And what about acknowledgement to these softwares? Because there is no way and the legality about it.
So definitely, sir. As you are rightly pointing out, if somebody has assisted with the software, it is always better to acknowledge it. So because I ultimately feel they should have the knowledge when they talk about it in a forum, or once they publish and present their work. If it's only the machine that is going to do it, they'll easily be exposed at a forum or something like that, where their knowledge also will be put to test. So it's always better that they acknowledge it, that this is a software I've used for my research methodology, or this is a software I've used for my maybe even a writing of a paragraph. But unfortunately, acknowledgements, I mean, sorry to say so, but acknowledgements even for humans is not happening, sir. So softwares, we cannot expect it to happen.
I would like to ask Dr. Joshi sir, whether you take some disclaimers while you accept such abstracts for publications, whether the doctor who is submitting it, they have to sign some disclaimer, like we have this financial disclaimer for we have used AI software for taking help for this paper or something like that, or can you add that now with the changing times? Can you add that tab that help of AI was taken and for what extent, something like that?
Yeah, in fact, in our instructions to authors, we have clearly written that you should acknowledge to whomsoever help you have taken up. And in fact, if I find that it has been used, Chat GPT or any type of software which has been used, I don't accept it, because it's not good to accept, because how I can send such type of papers to reviewers? Because even if I send them to reviewers, they find that it is a perfect one. What are the problem with the paper? And automatically they get accepted. So straight away at the editorial level only I reject them.
Yes, it is accepted that AI is going to be ahead. But still, at present, at least to my knowledge, AI is not as good as a good surgeon. That field of surgery is at present exempted on the AI. So they feel that the surgeons and physicians are better than the AI, because at the end, the softwares are working in the AI. First thing, whatever is in somewhere, some way or something, feed it to it in software methods or the experience method or the sensors on any method. They work on that only. But the human mind in surgery and medicine is totally different. And so at present, two fields they have cleared off from the AI, and one of that is the surgery and medical law field, which they don't say that they are the final and they shouldn't be believed totally. So man is at present super to the AI.
Sir, to add on to Rajesh sir's point, in articles, I always feel when there is a human touch, there will be an error, sir. That is one thing I always look into it. Where it will be a good article, but here and there we may be able to pick up an error. If the article is like too good to be true, then the skeptical thing arises. And as sir rightly pointed out regarding AI, so today the flights are an autopilot, but are we willing to travel in a flight where there is no pilot? No, because we still believe humans, and the takeoff and the landing, those are still done by manual maneuvers, which it's not that AI can't do it, but surgery also today for that matter, may AI is assisting maybe in biometry or maybe the calculations or refractive elements to arrive at, but humans are the ones. And finally, in the court of law again, as the doyens and the seniors here, you would be knowing much better than me, we cannot finally say the AI made the mistake. The doctor is going to be the one who's finally held responsible, and there is no way, no two ways about it.
Yeah, there is no escape to the doctor. They cannot say that AI has made the mistake and such thing has happened and negligence. But the thing is that AI is conducted by the doctor and the AI is not conducting the doctor.
Yes, sir. So that's a very valid point and great point. And I think this AI discussion is not going to end, and it's going to evolve more and more further. So for the next talk in our IC, I would request, I will call Professor Dr. Rajesh Joshi sir. He is professor and head of the department at Government Medical College, Akola, and is practicing at Orivision Eye Hospital. He's also editor of Journal of Cataract and Ophthalmic Research of MOS. He will be speaking on lessons from important landmark court judgments related to ophthalmology. Sir.
AIOS Scientific Committee, my friend Dr. Viral Shah, for giving me this opportunity. I will be speaking, there are no slides here. I will be speaking on lessons from important landmark court judgments related to ophthalmology. I have nothing to disclose. Now, whenever you are dealing with patients, you have at the back of mind some points which are there. Like, will this be patient, comma, are there any intraoperative complications which will be happening in this patient and I may be sued? Postoperative issues, whether the patient will get vision which you have really told to the patient, and medical legal problems, whether I will land into medical legal problem if I dealing with this patient, and last but not least is media harassment. Now, why we are burdened? The cost of technology is high in ophthalmology, but given the increasingly competitive environment and the social demand, there is a pressure to progressively lower the cost to the consumer. To keep costs down, there is a tendency to do as many surgeries as possible in an assembly line fashion, both in hospital as well as in the charitable camps. So this, I think, the main issue which is related to the medical legal aspects. However, recently the number of cases in which the courts have imposed exorbitant penalties have increased, destroying the careers of many ophthalmologists. Now we will see case by case, how this has happened, and we have something to take out of these cases. Now, Kerala High Court in 2018 awarded compensation of 22.5 million rupees for victims of negligence in ICAM which was partially funded by District Blindness Control Society. Now, the reasons which were given by Honorable Court were no approved was given, no approval was taken to run the hospital, consent to operate, the patient was not taken from the State Pollution Control Board, no proper design and maintenance of operating room, there were no anesthetists, no pharmacists, no facility to do preoperative laboratory tests, no formalin which was indented despite it being out of stock. So these were the reasons which were given by Honorable Court during the judgment part. Now, case number 2, Honorable Supreme Court awarded more than 26.5 million compensation, including 6% interest in one case for failing to diagnose retinopathy of prematurity against pediatrician who treated premature babies and hospital plus the state of Tamil Nadu. So these were the two important judgments which improved the practices of our routine procedures. Now this case 3 judgment of 1989, 84 persons in Khurja and 15 in Muradabad lost their vision due to endophthalmitis, which led to guidelines being laid for ICAMs. There were initially no guidelines for conducting ICAMs. Due to this judgment, now we have the various guidelines for conducting the ICAMs. Case number 4, patient of dengue developed intraocular hemorrhage and was seen by ophthalmologist after 13 hours. Complainant who finally lost his vision was awarded 3.5 million compensation despite correct treatment having been given by doctors. Delhi Medical Council and Medical Board formed by Maulana Azad Medical College had both exonerated treating doctor, but court disagreed with both these reports. So ultimately the compensation was awarded to the patient. Case number 5, recently a patient following LASIK surgery for high myopia underwent toric implantable collamer lens, and for unsatisfactory results, he claimed a sum of 60 million plus as a compensation. Thankfully, the court did not agree to such exorbitant claim, especially when the boy completed higher education after surgery and was gainfully employed and active on social media as found by investigators hired by the hospital.
Yes.
Case number 6, routine practices which are very important. Preoperative evaluation frowned upon frequently by courts. Now, it sometimes happens that we perform surgeries, but we don't do our routine investigations. Article about medical test before eye surgery when you need them and when you don't, by American Academy of Ophthalmology in 2017 form what are the investigations which are needed and what are not needed, which was referred by the court and quoted in State Consumer Dispute Redressal Commission of Maharashtra's case. Compensation awarded for not doing preoperative test as well as not taking proper consent, which was given by the court. Now the medical records are very important when you are seeing patients, when you are performing surgeries. No medical records means you are not, there is no guarantee for the judgment. Ophthalmologist on 24th day of birth had examined premature child and written on notes that no ROP was seen. The child was discharged and advised to come for follow-up in special clinic. Court observed that the doctor should have performed retinal examination with binocular indirect ophthalmoscope on dilatation of the pupil with scleral depression to ascertain whether a vascular zone at periphery of the retina was present or not. Nothing forthcoming from medical record that this was done. Court's view was that neither had doctor done examination for ROP nor had they advised follow-up for ROP for child. 6.4 million compensation was awarded in this case. So this shows the importance of keeping medical records. Case number 8, 9-year-old child underwent ophthalmic surgery for squint, suffered cardiac asystole at the end of the surgery. Successful resuscitation was done, but the patient continued to have episodes of asystole and bradycardia for which pacemaker was required. Patient subsequently expired when he was in ICU. Now the court concluded that the consent obtained from mother of the child was just a routine consent and not really an informed consent. Although the anesthetist claimed that retrobulbar block was given by surgeon, 3 documents, namely the anesthetic note, the ophthalmic surgery notes or physician progress notes had no mention of retrobulbar block. Word glyco was written instead of glycopyrrolate in OT record, and use of confusing abbreviation in medical record is a deficiency in service. Compensation was awarded on these grounds. Now, improper OPD prescription. Sometimes we write down the prescriptions even, and we don't know what we have written. If sometimes if that prescription bounce back to you. Post surgery for pterygium, doctor advised the patient to use mitomycin C, but committed error by not prescribing medicine for how many days and for how many times per day. Appellant, instead of coming back for checkup, continued using mitomycin C without consulting the doctor, which led to damage to the eye. Compensation was awarded as limited negligence of doctor for not writing a complete and proper prescription. So you need to write down on the paper that for medicine, particularly the name of the drug and not the company name, for how many days and for how many times a day you have to instill those drops. Contributory negligence by the patient was held by court in this case because he continued to take medicine on his own without consulting doctor. So in summary, medical records are very important. Always seek opinion of the colleague in view of any differences. Always protect yourself by indemnity insurance. Thanks for your patience listening.
Thank you, sir. That were some very important landmark judgments that you touched upon. There is a lot to discuss. I think we'll take some questions at the end after talk by Dr. Anand Deshpande, sir. Dr. Deshpande, sir, is from Chhatrapati Sambhajinagar. He is past president of Maharashtra Ophthalmic Society and is also on the Medico Legal Committee of All India Ophthalmic Society. So, welcome, sir. I will be speaking on dealing with legal notices. Be practical and prepared.
Yes, myself, Dr. Deshpande. What patient has sent a legal notice. Generally, whatever happens, whether it is happened with the patient doctor, whether it has happened with the staff doctor and patient, or somewhere, whenever their patient comes in the premises of the hospital, and if he is not satisfied, he can send a notice. But what is the importance of that notice to the doctor and hospital is also a very important thing. And what should be your next step when the notice is there? But generally, as we are little bit ignorant of the law, we immediately get disturbed because of that notice. And we start writing something, some answers, this answer, that, and you try to defend yourself. Whenever you are defending yourself, you are making so many mistakes because you are not a lawyer, not a law person, not know what that should be answered that way. But that the answer which is given in the legal notice can be used in the court against you if it is something written wrong. So what one should do? So as I am a legal committee, All India Ophthalmic Association, at this place I will like to say that we are shortly forming SOPs for everything which is going from patient coming in the OPD section to discharge and follow up for everything, which many consultants are being involved in that for doing the SOPs of specialty. And why the case is lodged, that is the main thing. Previously, it was only the clinical results that patient did not got and patient used to go in the court or give out the notice. But now, it is not that. Previously, behavior and other problems were not of importance. But nowadays, behavior of the doctor, behavior of the staff, ambience is also a matter now. If you are not clean, hospital is not clean, your bed sheets are not changed, your latrine and bathrooms are not clean, they feel and they can send the notice. And instigation is the most common thing. very, very small thing that I will like to say to all the practitioners, that we allow the patient and we say that one or two people with them. That is very bad method of saying that only one or two patient the relations should attend with the patient in the cabin. So other get feel that are we not important? Are we not really important for this patient? And they get disturbed and they instigate the patient. So better to allow them. It is nothing wrong for getting a 3, 4, 5, 6. The 2 chairs are there, 2 will sit and the remaining will stand, definitely. But everybody will be satisfied, and that satisfaction is very important in the medical field. So never say that only allow 2 accompanying people or 1 accompanying people. So the instigation is not by the only the relations, but there are so-called leaders in the town, particularly in villages. They say that they are not given the importance, or they instigate, and for so many reasons, for this and that, and frivolous complaints for earn the money is also a very common thing nowadays, because of the Consumer Protection Act 19 has a provision for that, I will say. Patient himself or through a advocate. How the notice is sent. Patient can send himself a notice, or he can send through the advocate. Should be cognizance taken of that notice? No. If you are going to answer that notice, better to have a medico-legal consultant, or at least an advocate, and then answer. Otherwise, don't answer. It is not mandatory to answer that notice. But when the notice is sent by the civil court, consumer court, or the national NMC, that is National Medical Council, or state medical council, or police station, or criminal court called as warrant, or other agencies such as health services, corporations and all that. That notices one has to answer. And answering that notice, don't say that I know everything. I am the master of everything, and I will write the notice answer very nicely. You are nowhere, because you are only master in your clinical field. I agree. You are master, super master. But in other fields, you are not master. You take the help now, and helps are available at every step. And that is very important. Unless you take the help, you make the mistakes, and that mistakes causes the punishment in the courts. So he will not refuse the notice, as even if you refuse, it will be taken. Many times the people think that I don't take the notice, so what will happen to me? Nothing will happen. I was not communicated. It is not true. If the notice is served, he will write it was served, but he refused. And the intention of the giving the notice is to only inform, not to let them know what the things are there in the notice. So never refuse a notice. It is not mandatory to answer the notice of the patient or the advocate that I just now said. Other notices answer with help of the advocate or medico-legal consultant. Have indemnity insurance, as doctor said just now. Then don't become panic even if you have received a net notice, because you are having nowadays many people around you, medico-legal advocates and all that. So medico-legal cases charged may be a case under the Consumer Protection Act 19. So there is a difference in between. I will categorize the notices in 3. That is, one is Consumer Protection Act, that is a civil charge. Another is a criminal notice in the criminal court, that criminal offense has been done. And third is administrative, that your latrines are not clean, this is not clean, you are not registered, your hospital, you are not registered for disposal of the cases, and all these are administrative. But notices can come from the health departments and the ministers and MPs, and that also you have to take the cognizance, because they are from the part of the public. maybe a part, patient may be a part of the public. So all these types of the notices are there, but the clinical notices are only, legal notices are only criminal or the civil. The mode of action of, differs according to whether the case is lodged. So when you are answering a notice, that mode of action changes if it is lodged in the consumer court, whether it is lodged in the criminal court. Apart from that, FIR or private medico-legal case, the FIR is lodged for private criminal case is lodged, then take the help of the medico-legal consultant. He will ask you the court to opinion of the medical board, and then only negligent is not gross, case will not be dismissed. So whenever the criminal case is lodged, FIR is there, or the criminal case is lodged in the criminal court, there will be a notice from that. And if they, even the FIR is lodged, they have to take the opinion of the experts, whether it is true or not, and then the case will proceed. Otherwise, it will be dismissed there only, or the court will dismiss, because before dismissing, he will have the opinion. But there is a mandatory for criminal cases only to the court. In civil cases, there is no mandate. If the court desires to take the opinion, will take the opinion, otherwise not. So police statement, police can come to you and ask for the giving the statement. You can give the statement, cooperate with the police, but need not to sign the statement. It is, statements are never signed. Patient, police can ask the, that is a record. You should show the record, but when they are seizing the record, they are taking it, have a copy of the record and ask them to do the panchanama. That is called as panchanama, which is to be done, and the copy of the panchanama should be preserved with you, and that should be shown in the court that the originals are being taken by the police. Otherwise, the court will blame that you are not having the originals. So now, whenever a complaint is received against a doctor or a hospital by the criminal court, then before, as I said, when the court receives the complaint in the complaint, they will send all the documents to the experts or a government of civil surgeon or medical board, and will take their opinion, and then will decide. And when you are for a few minutes, Dr. Shah, yeah, you will have your written statement in the consumer court. The consumer court is totally different, and in that case, you have to give the written statement, and that written statement is the important thing, which decides the case totally. And so you should take the help of the medico-legal consultant. And nowadays, Consumer Protection Act 19 has changed a lot, and the negligence is not the only cause of your case. And if whether you are where you are working, whether you are a solo worker, that is solo practitioner, you will be case will be on the you. But when you are working in an organization, trust hospital, corporate hospital, or somebody else's hospital, the whole blame or whole goes to them, because in consumer it is said whosoever pays is consumer, and whosoever gives the services is the service provider. And in that hospital is service provider and doctor is not the service provider, because doctor gives his services to the hospital and not to the patient. Though indirectly they goes to the patient. Role of the medico-legal consultant, and that was decided by the Supreme Court, and they said that whenever a patient comes to such hospital, it comes with the name of the hospital and not on the name of the doctor, though he may be coming on the name. But bill is taken by the hospital, bill is not taken by the doctor, bill is not maybe shared, but not totally going to the pocket of the doctor. So he is not a service provider, and patient is not consumer of that doctor. So he is away from that case totally. So this Supreme Court decision is in favor of that, and so doctor need not to worry. And indemnity insurance has said, and how to avoid a case is speak less, hear more. Thank you very much.
Thank you, sir. That was the right way to tackle legal notice that you receive whenever there is some mishap or a patient feels that there was some negligence, you should not panic but be prepared and go about it step by step. So if there are any questions from the audience, we can take it now.
If there are no questions, I just want to ask Deshpande sir, if suppose a government doctor gets notice, then how to proceed further?
First thing, that government doctor cannot get a notice of a consumer court. If he gets a notice of the consumer court, that is the responsibility of the government. Even the government hospitals like medical colleges or the government hospitals where the charges are charged to the patient according to their income may be minimal. They are consumers, and so they have to do all that, and doctor is the service provider. He is on the contract of the service and he is not the culprit. Secondly, whenever a government doctor hospital, when working in the hospital, he gets the notice from the upper higher authorities, that is the DHO director or somebody else or the political leaders, he has to inform to the hospital superintendent or hospital head, and they will answer, and he will be answerable to the hospital, not directly to them, because he is an employee under the contract of employment, and he is not the whole soul who has to answer everything.
Sir, how much insurance you suggest? You mentioned about the
Nowadays,
insurance part
you cannot say how much is sufficient, but at least I will say minimum 1 crore should be there. And for that, Maharashtra State Ophthalmic Association and All India Ophthalmic Associations are brought the premium from 30,000 for 1 crore to merely 6,000 by AIOS and 8,000 by Maharashtra Ophthalmic Association. So one should have at least 2-3 crores, because 5,000-6,000 per crore is nothing. Once we go in the canteen or hotel, we spend more than that. So why should not be peace of mind? You should not have that.
Yeah, thank you, sir. One more question. While taking this insurance, there are many companies which are providing this insurance, and there are many rules which we usually don't read. What you should really see in the condition part of this insurance while taking this insurance?
Yeah, there are 2 things very important you have to see. And that is when you are taking a 1 crore limit, suppose I am saying 1 crore, what is the ratio that 1:1, 1:2, 1:4, 1:4? That ratio matters a lot, because that ratio says that in 1 year, how many cases you are going to deal. So if the ratio is 1:1, the whole 1 crores is compensation is available at your hand if the court orders. And if it orders less, suppose 60,000, 60 lakhs, then remaining 40 lakhs remains for next case. But when you put it 1:4, only 25 crores remains with lakhs remains with you for paying by the insurance company. Remaining you have to put from the pocket. So that is a very, very important thing. Never see that what is the ratio, and never accept any 1:2, 1:3, and 1:1 is the best. Secondly, your part of payment, there is a clause. From your pocket you have to pay something, 10%, 5% or something, and that should not be very high. So see that it is a minimum when you are taking. And best way is for ophthalmologist, at least though both the things, AIOS is there and MOS is there, and group insurance has brought a lot of things, but it is not the group, but the member insurance in group. So everybody is having their own individual insurance through AIOS agency. So that is a secured one.
Yes, sir. That was a very well taken point. 1:1 or 1:3.
No,
1:1 you have to
Yeah,
always go for
1:1.
It means that if you are insured for your professional indemnity insurance is for 1 crore, if there occurs more than 1 cases, for each cases 1 crore will be allotted.
Yeah.
Whichever case gets decided first, some payment will be there in the next year.
But generally, any
But
doctor
if there is
or
a cluster,
hospital-
suppose some 5-6 cases occur, and they all go simultaneously, so 5 cases, for each case 20 lakhs will be maximum applicable limit for that. Yeah.
Generally, a individual doctor generally happens more than one case in a year. Next year again, the same is there. So better to have 1:1.
Yes, please,
Yeah,
sir.
please.
I'm seeing an example where due to false case, the complainant has been taken charge of by the court. The doctor has been compensated for defamation also.
If the false case is there, you have to prove that it is a false case. And if the false case, you cannot prove that it is a false case, you have to pay the compensation. It
Ne-
becomes true case then.
What was the case? What was the case?
My question is, they have complained, and during the proceedings, they are somebody has instigated it as a
Settled. They have settled the case.
in the court only that these people have trying to frame the hospital or the doctor. Does it go naturally to the point that the complainant has to give compensation to the institution?
Now,
Or you
in
have to take it for actively take it up later?
No, you have to actively taking it up for perjury and against false under section 206 of Bharatiya Nyaya Samhita, registration of false complaint against a doctor. You have to prove that there was such a complaint. You have to go to the police station and say such false complaint was there, and again that will be a separate case. This will be a separate case. Right, sir?
yeah, I will add to this false complaint, whether it is a civil or a criminal. If it is a criminal, even if you register another criminal case on him, it doesn't matter, it will separately go on. In civil case, that it goes to the media. Now, mediator. Every case goes to the mediator, and mediator you
consumer-
have to say
in consumer
something
court.
and then settle if you want to, or you contest again. Yes, please.
Like you have told in your talk that if police comes to the hospital,
Better have mic, madam.
You can come here. You can come
Or
here.
come here and speak with the mic.
good morning, sir.
Yeah.
Like in your talk, you have told that if police comes to the hospital and asks for statement from the doctor, and the doctor is giving the statement, but he is not signing it. What is the idea behind not signing the statement for the police?
Yeah, that signing is never given to the any statement to the police, whatever. It is not for the doctors only. For others also, when the police is doing the enquiry, that is their enquiry statement, and that is not your commitment or declaration. When you sign it, it becomes your declaration.
And it stands in the court then?
Yeah, it stands court, but
Okay.
court refuses to make it stand. They say that why you have taken the signature, they fire the police only.
Okay.
Because so moto we don't do. So they forced to sign.
Yes.
So court say why you have made it to sign. But generally they don't force you or say that sign it. That is their rule.
So if you
Because-
don't sign, then it is not a declaration, it is
Yeah,
just a
yeah,
statement which can be
yeah,
changed
yeah.
afterwards.
It
maybe.
is your legal right if you
Yeah,
don't want to sign.
yeah.
You
Okay,
can
it
give
is
any
our legal
statement.
right.
becomes
That
whenever
we
you
should
sign,
know.
it becomes
They can
actually.
note down anything
Because
on the
the
statement.
policemen, they might force the doctor, and we are not aware many times.
Even if you
most of the
sign,
times.
it doesn't stand in court.
Okay.
Yeah.
One
But,
point. Second point, it is a tactics by the police department.
yes.
That once you sign, you will not waver from your whatever you say.
yes.
You say something now, and they go through that investigation line, and then you completely do a somersault and say something else. So their whole time is get wasted.
that
So
is-
that
but
is
that
their
is
police
false.
tactics.
That-
only.
No, secondly, patients are very clever. They put the cases both place, at criminal and civil in consumer.
Okay.
And whenever you sign the statement, that
stand in
there,
consumer
they
court it is.
produce it in the consumer
Okay.
that he has agreed this. So agreed this means that
So
is
in
sufficient.
consumer court, it stands if we
It
have
stands.
signed
It
before.
It has some
because that
weightage.
is a
It has
document.
some weightage.
Okay.
Yeah.
So
it
we should
has-
not better it is
yeah, it
not
has
to
weightage,
sign.
Yeah.
Okay.
It
Thank you so
stands.
much, sir. Thank you.
One last thing.
Yeah, please.
The importance of video recording of consent. How important is that nowadays?
Yes, video consulting.
Also, or only in high risk?
Yeah, now the NMC has made compulsory the writing or everything should be a computerized one. After the 3 years, that should be. 1 year is passed. The NMC has directed everything to be converted in computerized
Electronic medical
matter
records.
in 2 years again. So whenever you are taking a video consent, it is not the video consent of saying. the hard document should be there, should be signed, and that signing and everything, and when you are explaining everything, the complications and all that, that should be in the video.
For 3 years.
Yeah. But whole the thing, you just said that video and he said, okay, I agree. That is not sufficient.
What sir is saying is after 3 years it is going to become compulsory
Yeah,
for
compulsory.
everyone. That is what NMC has recommended.
Yeah, recommended.
And for what period of time you have to keep that video, that is a separate question. And one, it is not mandatory right now, but it is desirable if you can take video consents.
And
But
in
written consent is a must.
And in future, it will be compulsory to capture his thumb and his face also, because that is the
Biometric,
identification
yeah.
of the. Many times they sign it and they say in the
This is
court that
not
this
my-
is not my sign. So better for our safety at present, you should have a thumb impression attached to your computer and a camera which captures his image and put it on his case paper, both the things. So it becomes revealed to everybody that you have not done anything wrong.
So sir, with your kind permission, shall we conclude the session?
Yeah.
So thank you everyone for joining us for this IC, Medico Legal Updates, current scenario for ophthalmologists. Dr. Deshpande sir from Sambhajinagar, Dr. Rajesh Joshi sir from Nagpur, myself Dr. Viral Shah from Nagpur, and Dr. Venkatesh from Trichy. Yeah. So,
Front or? Pude.